as we have already studied that what we call the intra-territorial jurisdiction, where we have studied if any offense has been committed by any Indian national or by the foreigner, irrespective of his nationality, within the territory of India, then he shall be liable to be dealt with under the Indian Penal Code, and he shall be prosecuted by the Indian courts, and Indian courts would have jurisdiction over him. Similarly, if the Indian national is committing an offence outside of the country, then again the Indian courts would have jurisdiction. Similarly, not only the mainland, rather the ship which are registered in India, aircraft which are registered in India, and the ship which is in high sea shall be considered to be the mainland of India, and if any crime is committed in the high sea and if the sea is registered in India, then the Indian courts would have jurisdiction. So basically, in case of inter-territorial jurisdiction, we are deciding the facts and the cause of action on the basis of it was committed within the territorial limit of the court or within the jurisdiction of the court. And we have also studied that what we call the jurisdiction is made up of by the two word juris plus dicto, which means I speak by the authority of law. If the court is having no authority, then the court cannot pronounce a judgment, the court cannot try the case. For example, if the court is having power to try a civil matter, and if the court is trying a criminal matter, then again the court will not have any jurisdiction, or the judgment pronounced by the court would have ultra vires effect, and that judgment would be called as null and void judgment. Now come to the point, extraterritorial jurisdiction under the Indian Penal Code 1860. For studying extraterritorial jurisdiction, you must study Section 3, Section 4 of the Indian Penal Code, and the Article 245 plus 2 of the Indian Constitution. So let us see what Section 3 of the Indian Penal Code says. As per Section 3 of the Indian Penal Code, punishment of offences committed beyond but which by law may be tried within India. What does it mean? The offence has been committed beyond India. This particular line is a very important line. The offence has been committed beyond India, but which by law may be tried within India. What does it mean? We have already a law to try a case, to try an offence which has been committed beyond the limit of India. What does it mean? It has not been committed within the territorial boundary of India, either in high sea. Then what it further says, it says any person liable. Here again we have already studied that what we call any person here means a natural person, either man or woman of any age, and not the juristic person, because the juristic person cannot do a crime like robbery, murder, dacoity, rape. So therefore here any person means the man and woman of any age. So any person liable by any Indian law. So the person is not only liable under the Indian Penal Code, rather he may be liable under any criminal law, any Indian law, to be tried for an offence committed beyond India. Point number two, to be tried for the offence committed beyond India. So the person is liable just because he is liable under any Indian law. So it is not only referring the Indian Penal Code, it is not only referring to this code, rather any Indian law. So the person is liable under the any Indian law to be tried for an offence committed beyond India. So he has committed an offence beyond India, but he is liable under the Indian law. Point number three, shall be dealt with according to the provisions of this code. So he shall be dealt with according to the provisions of this code. That line is very important. Point number three is very important, that he is liable in any Indian law, and he be tried for an offence committed beyond India because he is liable in any Indian law, but he shall be tried according to the provisions of Indian Penal Code. Although he is liable in any other law, but he can be tried within the provisions of the Indian Penal Code. That is the crux of the line, for any act committed beyond India. So he has done any act and you know the act includes the omission too by virtue of section 33 of the Indian Penal Code. So if any act or omission has been committed by any person beyond the limit of India and he is liable in any Indian law, but he shall be tried according to the provisions of the Indian Penal Code in the same manner as if such act had been committed within India. That's a very crucial line, that's a very important line. In the same such act has been committed within the limit of India. So he shall be tried in the same manner as if the act has been committed within the territorial limit of India. Section 3 and 4 deals with extraterritorial jurisdiction. I repeat, Section 3 and Section 4 deals with the extraterritorial jurisdiction of Indian criminal courts, and court will have jurisdiction over citizen of India both within and beyond India. What does it mean? If the if any Indian national committing an offence within the India, then definitely we have inter-territorial jurisdiction, for which we have Section 2 of the Indian Penal Code. But if the Indian citizen is committing an offence beyond India, then whether Indian Penal Code would have jurisdiction? Of course, by virtue of Section 3 of the Indian Penal Code, the person would be liable under the Indian Penal Code, because here it says any person, and here any person includes either Indian national or the foreign national. So if any Indian national is committing an offence beyond the limit of India, then again he shall be liable under the Indian law by virtue of Section 3 and Section 4 of the Indian Penal Code. Now come to the point that how, now a question certainly may come in your mind, that how Indian law would be applied to an offence which is committed beyond the limit of India, whether Indian Parliament would have jurisdiction over such issue, because the crime has been committed in America, the crime has been committed in France, Germany, Nepal, Pakistan, Afghanistan. So it has been committed outside of the country. So how Indian courts would have jurisdiction? So the answer is Article 245 plus 2 of the Indian Constitution. Article 245 of the Indian Constitution that gives power to Parliament to make law on any subject matter. So, by virtue of Article 245 Clause 2, which gives power to the Parliament to make law which would have extraterritorial operation. If a law which is having extraterritorial operation, still it shall be deemed to be valid. What it says? It says no law made by the Parliament shall be deemed to be invalid on the ground that it would have extraterritorial operation. So you cannot question a law before the court, before the Supreme Court of India or before the High Court, that it would have extraterritorial operation. Even if a law is having extraterritorial operation, still it is a valid law by virtue of Article 245 Clause 2, because the Article 245 Clause 2 giving the validity to Section 3 and Section 4 of the Indian Penal Code to have extraterritorial jurisdiction over an offence which is committed beyond the limit of India. Now again a question may come in your mind, that if a foreign national committing an offence outside of the country, whether he can be tried within the limit of India? Certainly not. The answer is certainly not. If a foreign national committing an offence beyond the limit of India, then he shall not be tried within the limit of India, because he is subject to the jurisdiction of any other country. He is a national of any other country. But if he is committing an offence over a ship which is registered within the territory of India, then he shall be tried and prosecuted by any Indian courts. Come to some illustration. Suppose an Indian citizen who is committing an offence of murder in Nepal, then he will be liable to be prosecuted within the territory of India, because he is an Indian national and he is subject to law made by the Indian Parliament. So therefore, if he is committing any offence beyond the limit of India, wherever in the world, either in US, UK, France, Germany, anywhere in the world, if he is committing any offence, if that offence is defined by the Indian Parliament in any law, what Section 3 says, he is liable to be tried in any Indian law. So not only it is not mandatory requirement that he shall be liable within the Indian Penal Code. No, if he is liable, because the Indian Penal Code is a general penal code, it is not a special law, it is a general law. So therefore, if he is liable in any Indian law, then he shall be liable to be tried by the under the provisions of the Indian Penal Code. Point number two, that the scope of the section 3 is very wide enough. That means it is not only uh, making Indian citizen liable for the offence committed beyond the limit of India or the abroad, uh, rather it is also making the liable to those persons who can be well within the Indian province. If he is committing an offence, if the foreign national is committing an offence, if he is committing an offence with respect to India, then again he shall be liable for the offence. Let us take another example. For example, adultery. Although adultery has been declared unconstitutional, has been decriminalized by the Supreme Court of India in the year 2018 in the case of Joseph Sine versus Union of India. But suppose if an Indian national is committing an offence of adultery in UK, where the adultery was not an offence before, I'm talking about pre 2018 judgment. So, if an Indian national committing an offence of adultery in UK, then he might have tried within the territory of India, provided his presence can be secured within the territory of India. So, what does it mean? Again, we know that adultery is a ground for divorce under the Hindu Marriage Act. So, let us take another example. If suppose the bigamy is an offense, the bigamy is an offense under 494 of the Indian Penal Code. So, if any person is committing an offense of bigamy, then he shall be tried. Suppose it is permitted in the US, and if he is committing the offense of bigamy, then he can be tried within the limit of India. The person can be tried within the limit of India, and the Indian courts would have jurisdiction over the issue. Now, come to a very important aspect of the extraterritorial jurisdiction, as we have already studied that for extraterritorial jurisdiction you must study section 3, section 4 and article 245 clause 2 of the Indian Constitution. So let us see what section 4 says. As per section 4 of the Indian Penal Code, extension of code to extraterritorial offenses. So it clearly says that our code is having extraterritorial operation. If any offense is committed beyond the limit of India, then section 4 would come into picture, and certainly the person would be prosecuted and tried within the territory of India by the Indian courts. So, as per section 4, the provisions of this code apply also to any offence committed by any citizen of India in any place without and beyond India. But it says the provision of this code, it is talking about, certainly it is talking about the provisions of this code, whereas section 3 is not only talking about the provisions of this code, rather that is wide enough. Section 3 is wide enough to include the offense committed in any other Indian law. So section 3 and 4 are somehow different. Section 3 is wider than the section 4. So the provisions of this code apply also to any offense committed by any citizen of India in any place without and beyond India. So clause 1 is talking about if any Indian citizen is committing an offense without and beyond India, then he shall be prosecuted within the territory of India. So how he can be prosecuted? He can be prosecuted by virtue of extradition process. So if any Indian citizen is committing an offense within the territory of India, and if he escaped from the territory of India, for example, the Mehul Choksi, Nirav Modi. So there are various offender who escaped from the territory of India, so they can be extradited, they can be bring back through the extradition process, and they can be tried within the territory of India. Point number 2, any person on any ship or aircraft registered in India wherever it may be. That's very important line. Any person, here the any person, it indicating the foreign national. If a foreign national is committing an offense over any ship or aircraft which is registered within the territory of India, which is registered in India, wherever it may be. Wherever it may be, it is not mandatory that it is within the 12 nautical mile from the appropriate baseline of India, or 24 nautical mile from the appropriate baseline of India, or up to 200 nautical mile from the appropriate baseline of India. No, it is not a mandatory requirement. Even if it is beyond the 200 nautical mile, if it is in high sea, still Indian court would have jurisdiction, because subsection 2 of section 4 says so. It says any person on any ship or aircraft in India, where registered in India, wherever it may be, wherever in the world it is, even if it is in, on the coastal area of the US, on the coastal area of UK, still the person can be prosecuted within the territory of India, because the ship was registered in India. Point number three, any person in any place without and beyond India committing offense targeting a computer resource located in India. That's provision added by the Information Technology Amendment Act 2000 by virtue of Section 2K of the Information Technology Act 2000. So that particular provision was added in the year 2000. So any person in any place without and beyond India. So if any person who is outside of the country targeting a computer system, computer network, a computer resource located in India, then he shall be tried and prosecuted within the territory of India by the Indian courts, and Indian courts would have jurisdiction. He cannot say that while targeting a computer system, computer network outside of within the territory of India, he was outside of the country, and therefore he cannot be come within the purview of the Indian courts. He cannot claim such a defense, he cannot put forward such a defense, and therefore he can be tried by virtue of subsection 3 of section 4 of the Indian Penal Code if he is targeting a computer system, computer resource within the territory of India. Now, certainly a question may come in your mind that what is the rationale behind the making of section 3 and section 4 of the Indian Penal Code? The rationale is the rationale of this section is that every sovereign state can regulate the conduct of its citizens, wherever he or she may be. Even he is in France or Germany, he is subject to Indian law. Although if he is entering in any other country, he is subject to that law, that country's law, but also he is subject to Indian law. He cannot do an act which is a crime within the territory of India. If he is doing, then definitely he shall be liable within the territory of India. For example, if in Indian national committing the offense of murder in France, then he can, of course, he can be tried in France and he can be punished there, but as well as he can be tried in India and he can also be punished here. But generally it is not it doesn't happen. Rather, the country in which he is committing the crime, there he can be tried and punished under those laws. Otherwise there would be double geo pardai. So if any person committing an offense beyond the limit of India, if he is Indian citizen, then he shall be tried. Now let us take another example, the bigamy. If suppose if a person having a wife and three children went to the US and he married again, and therefore it is an offense of bigamy under section 494 of the Indian Penal Code, and therefore he can be tried within the territory of India. He can be prosecuted by the Indian courts. Now come to a very important question, a very crucial question. Non-citizen. What about non-citizen? If a non-citizen committing an offense without and beyond the limit of India, whether he can be tried within the territory of India by the Indian courts? Certainly not. Underline the term certainly not. If a person who is not an Indian citizen, if he is committing an offense in UK, US, or in any other country, then he shall not be tried within the territory of India, even though if he is obtaining the Indian citizenry later. After committing the offense, if he obtained the Indian citizenship, still he shall not be tried for the offense which was committed before the obtaining the citizenship. Come to the concept called extradition process. How extradition process is being effected? The extradition, in case of extradition process, there are two countries One is requesting country and other one is requested countries. For extradition process, there must be an agreement, there must be a bilateral agreement between two nations. So suppose a crime has been committed. Suppose Mehul Choksi committed a crime within the territory of India, the economic offences, and thereafter he escaped from India to England. Then in that case, India would be a requesting state and England would be a requested state. If India would request to the England, then England would hand over the person to Indian police, and thereafter he can be prosecuted and he can be tried and prosecuted within the territory of India. So there are certain exemptions. For example, it should not be a political crime. The person should not be should not committed a political crime. If he is committing a political crime, then he would be protected under the international law. But in case of normal crime, for example, murder, dacoity, rape, or whatever offences are defined under Indian Penal Code, then in such a situation, he can be bring back to India, and thereafter he can be prosecuted. Let us take the example of Abu Salem. He committed an offence within the territory of India and thereafter escaped and went to Portugal. Since there was no extradition treaty between India and Portugal, and therefore he could not extradited, later on Indian government uh, uh, did an agreement with the Portugali government, and thereafter he was extradited to India, but with the condition that he shall not be given death penalty. So therefore, Abu Salim was not given death penalty. Rather, the Indian court has awarded him a life imprisonment. Come to the point, admiralty jurisdiction. This we have already studied that what we call admiralty jurisdiction. Admiralty jurisdiction are applied to ship aircraft. So if a crime has been committed which is registered in India, wherever it may be, even if it is in high sea, even if it is on the coastal area of any country, still the person is committing an offence, whether he is Indian national or the foreign national, irrespective of the fact of his nationality, he shall be prosecuted within the territory of India by the Indian courts. Come to the point, the cybercrime. If any person who is committing an offence of which is defined under the Information Technology Act. For example, targeting a computer system, a computer network within the territory of India. If he is targeting such computer system or computer network within the territory of India, then he shall be tried and prosecuted within the territory of India. The reason is the computer system and computer network is located within the territory of India, irrespective of the fact where the person was outside of the country. Even if the person is outside of the country, irrespective of the fact whether he was Indian national or not, even if he is a foreign national targeting a computer system within the territory of India, he shall be prosecuted and tried and punished by the Indian courts. Hope you might have understood that what we call the intra-territorial jurisdiction and what we call the extraterritorial jurisdiction. Thank you so much.